Good morning, everyone. It's good to see you all. All right. So I love to start every meeting on time, whether it's an internal meeting within our firm or a webinar that we're given. So it is 10 a.m. and I wanted to welcome you all. I think a lot of you know me. You're either a client or a friend or someone I thought that could use, a little refresher on exempt and non-exempt employees and their classification. And if you have any questions at all throughout the presentation, please feel free to send a message through the chat or the Q&A as we go along. So happy Friday again, everyone. I know you're starting to pour in right now. So for today, these are the topics that I wanted to talk about. Federal and state law exempt certain employees from wage and hour requirements, including overtime pay and meal and rest break requirements. And if you have a problem distinguishing between exempt and non-exempt employees in your company, you're really not alone. Some of the largest multi-million-dollar awards of back pay by the court system from employers' misclassification of non-exempt employees as exempt from overtime. So this happens to every business. And I wanted to cover employee classifications, specific exemptions that are the most popular that our clients use in California, some timekeeping practices, as well as recent legal updates, things that you want to be aware of as you're running your business, and then some of the biggest mistakes we see as employment lawyers. So the subject is particularly difficult for California employers, surprise, surprise, because the state's exemption requirements create more restrictions than just federal law, right? So as defined in the Industrial Welfare Commission wage orders, California's requirements usually exceed the federal standards adopted by the U.S. Department of Labor, making those federal standards generally irrelevant basically to California employees and California employers. So today we're going to dig into the issues and discuss employee classification, specific exemptions, timekeeping, legal updates, and then some mistakes we see. And because I'm an attorney, I do want to share with you that content on this webinar is not considered legal advice. It really is for informational purposes only. Communications made through this webinar and or by participating in it do not create an attorney-client relationship, and we're not responsible for any content that you may access from third-party resources that may be linked through this webinar. So, employee classifications, exempt status, because it is a highly litigated area, understanding the distinction between exempt and non-exempt employees is really critical here. So generally, exempt employees are your key personnel who process management and decision-making responsibilities. Because of the complexity of this area of the law and the potential for fines and awards of back overtime pay when an employee is misclassified, I wanted to set up an extensive discussion on this subject. The key point I really want you to remember here is always assume your employees are non-exempt unless they clearly meet the salary as well as the job duties tests for an exempt position. And so an exempt employee is normally an executive, administrative, or professional employee. And I do want to note that administrative, as written here, does not mean your administrative assistant is exempt. We represent a number of law firms who have made this mistake in the past, thinking that their administrative assistant is in fact exempt when they are not. Other exempt employee types include some salespeople and computer professionals. All non-exempt employees are covered by the state and federal wage and hour laws. So to avoid paying overtime premiums, an employee must be exempt from the overtime requirements of both federal and state law. And you want to make this determination as to the appropriate classification for a position at the time of recruitment for the open position, and then regularly audit your job descriptions to ensure that the position still meets a claimed exemption. Now, in order for California employees to be exempt, they must generally meet the strict job duties test particular to each exemption. Job titles alone do not designate an employee as exempt or non-exempt. And so if, for instance, you have an employee with an impressive job title, and I do have a lot of smaller clients do this, where they have 7 people in their office and they make everybody a department head, but there's no one underneath them. And so in that scenario, those people are actually not exempt just because of their impressive job title of department head. So an employee who performs, routine bookkeeping tasks does not become an exempt employee simply by giving them a title of controller rather than bookkeeper, right? And so giving an employee similarly the title of store manager does not actually make them exempt under the managerial exemption simply because they're doing a lot of the things that a normal employee non-managerial would be, such as serving customers or opening the store, or closing the store alone, or maintaining a merchandise display, or essentially any other function or of performing the work of a retail clerk. So remember that all employees generally fall under the non-exempt category unless they meet the specific exempt requirements. So your default here needs to be non-exempt unless you prove otherwise. Similarly, remember, I've been giving a lot of talks on independent contractors over the last several years. But similarly, with regard to anybody who's working for you, the burden is on the employer, right? And the presumption there is that everybody working for you is an employee. If you want to prove that they are an independent contractor, it's the burden is on you to prove that. And so similarly, the burden here is on you to prove that the employee is actually exempt. So the default is everybody's non-exempt and everybody is an employee. And this is extremely important to understand because all non-exempt employees are covered by the state and federal wage and hour laws. And so before we get into each specific exemption and what you want to keep your ears open for in your business, I wanted to discuss some of the general requirements. And so there is what's called the minimum salary test, and properly classified exempt employees generally must meet a specific minimum salary test. Under California law, the most common exemptions require employees to earn a minimum monthly salary of no less than 2 times the state minimum wage for full-time employment. And the salary must be a predetermined sum. It cannot include payments in kind, such as the value of a meal or the value of lodging. This minimum amount may also not be prorated for part-time work. And that's what happened a lot to our clients last year and our friends last year who decided to, furlough some people and take somebody who was working 40 hours a week, let's say making $80,000 down to $40,000 a year, and then they would only be working 20 hours a week. That type of calculation does not hold up in court. You are going to be sued for that, or if you're lucky, maybe not, but there's a big problem there. And so just remember that the minimum amount may not be prorated for part-time work. There are different rules for some employees, such as hourly physicians, computer professionals, and salespersons. However, the most important thing you can take away from this general rule is merely placing somebody on salary does not exempt that employee from wage and hour laws. A non-exempt employee placed on salary earns overtime just as hourly earners do. So I want to make that clear. And I should have put this on the slide actually, but the minimum monthly salary requirement for exempt executive, administrative, and professional employees is no less than 2 times the state minimum wage. And it's based on the state minimum wage, not any applicable local minimum wages. And so oftentimes we get questions from clients, well, LA has a higher minimum wage than the state. Do we have to go based on that? And no, you do not. It's based on the state minimum wage. And the minimum salary threshold, if you are a little bit of a smaller business with 25 or fewer employees, the minimum salary, the minimum state hourly rate is $13 per hour. And that went into effect January 1st of this year, 2021. And accordingly, the minimum monthly salary test is $4,506.67 per month, which equates to $54,080 per year. Now, if you're a little bit bigger of a business and you have 26 or more employees, the state minimum wage is $14 per hour as of January 1st, 2021. And that monthly salary equates to $4,853.33 per month, which is equivalent to $58,240 per year. So how clients can get into some trouble is they have somebody on salary who's making somewhere in the 50s, and then January 1st hits and they don't raise those minimum salary thresholds. And so by not raising those minimum salary thresholds to your exempt employees, you've essentially taken them out of exempt status, and then you need to calculate overtime and everything else associated with a non-exempt employee. That we have cases in litigation that are exactly based on that issue, where the minimum wage went up, nobody was paying attention to those employees, and now our clients have been hit with, have come to us after they've been hit with a wage and hour lawsuit. So another important part about the salary is that they receive your employees receive a predetermined amount each pay period. And so in order to meet that minimum salary test, the exempt employee must receive a predetermined amount consisting all or part of his or her compensation for each pay period. The amount cannot be reduced because of variations in the number of hours worked or the quality of the work performed. Again, this is just the general rule for the executive, administrative, and professional exemptions. There are certain exceptions for certain computer professionals and physicians, which we'll get into in a little bit. But aside from these exceptions discussed, the exempt employee must receive his or her or they's full salary for any week in which the employee performs any work without regard to the number of days or hours worked. And as a general rule, you need not pay an exempt employee for any work week in which he, she, or they perform no work. So another part of it is that the employee is primarily engaged in exempt work. And so the exemptions we're going to cover today require the employee to be primarily engaged in those exempt duties. To determine if the employee is primarily engaged in exempt work, the labor commissioner examines all the work that the employee performs during the work week. And then the labor commissioner considers the amount of time the employee spends on exempt work, as well as your realistic expectations and the realistic requirements of the job. In general, the employee must spend 50% or more than 50%, not 50%, but more than 50% of his, her, they's time performing those exempt duties. And you really want to exercise some caution here in your business if you have managers that supervise employees and at the same time perform routine non-exempt tasks, such as, stocking a shelf or answering the phone, managing a phone line, something along those lines. We did have a client of ours who owned a retail store where the manager, in addition to supervising staff, performed other duties like checking out the customers and stocking the floor and serving as a cashier. And because the manager was not performing those exempt duties, the issue was, opposing counsel was saying the manager is not performing those exempt duties more than 50% of the time. And of course, we were arguing that, of course he was. We had to break down the day and really argue that point that he was in fact performing those duties 50% more of the time, because they were claiming that the manager was in fact misclassified. And so this can be a potential landmine for smaller businesses who may have employees that have to wear different hats depending on the needs of the business. Using discretion and independent judgment is another area where most exemptions that we're going to talk about today require the employee to customarily and regularly exercise discretion and independent judgment. Now, discretion and independent judgment involve comparing and evaluating possible courses of conduct and acting or making a decision after considering various possibilities. So they basically need to be able to use their brain a little bit. So an employee having discretion and independent judgment must have the actual power to make independent choices pertaining to matters of significance, which is free from the immediate supervision of the higher ups, or have the ability to make a recommendation for action that is subject to a superior's final authority. So the employee must possess sufficient authority for the recommendations to affect matters of consequence to the business or its customers. We do have a lot of clients who, outright own their business 100%. And so, if that's the case, how do you put in a manager and give them that independent judgment and discretion? Well, you can still have the final authority if it comes down to you as 100% business owner, but they have to be able to basically chime in, make those recommendations. And to customarily and regularly exercise that discretion and independent judgment is to use it frequently in the course of day-to-day activities. So the phrase customarily and regularly basically signifies a frequency that is more than occasional, but less than constant. So these types of activities do not involve exercising discretion and independent judgment. If you have somebody applying knowledge to follow prescribed procedures, right? Determining which procedures to follow, determining if specific standards are met, determining if an object falls into one or another grade or class. Those all do not involve exercising discretion and independent judgment. We also have a lot of clients with great standard operating procedures, right? SOPs. And so if you have an employee just following those, that again is not exercising discretion and independent judgment, because obviously almost every employee must make a decision requiring some sort of discretion. We're not all robots, right? So the discretion and independent judgment exemption requires that the decisions must involve matters of consequence, of real and substantial significance to the policies or general operations of your business or your customers. And these tasks can be related directly to only a particular business segment, so a specific department maybe, but must substantially affect the business as a whole. And then exercising this discretion and independent judgment on matters of consequence is different than making decisions that can lead to serious loss through the choice of wrong techniques or improper application of skills or neglect or failure to follow instructions. So for example, if you have employees in training for an exempt position, they are not yet exempt because they do not yet possess that exercise of discretion and independent judgment while they are in training. So we're going to get into some specific exemptions, starting with the managerial exemption. I gave a talk, it was a couple of years ago now, to actually a group of lawyers. And I had one bankruptcy lawyer in the group ask me, well, what if I make a manager of my law firm, in charge of the paperclip? And he's just in charge of the paperclip. Obviously, it was a ridiculous question, but every time I'm on the managerial exemption, it makes me think of that question, because the executive exemption usually covers managerial employees, right? So supervisors often do not meet the executive exemption and must be classified as non-exempt. So to determine if an employee is properly classified under the executive exemption, consider the duties that he, she, or they perform, as well as their salary. And just another note on salary, I should have mentioned this earlier. I've had clients say to me multiple times over the years, well, I'm paying a manager on salary, and they're making, $30,000 a year, flat $30,000 a year. That's what they make. And you have to remember that that doesn't meet that minimum salary threshold. So anyway, an executive employee is exempt from overtime if they basically meet these requirements listed here, whether they have the duties and responsibilities involving the management of the enterprise in which he, she, or they is employed, or of a customarily recognized department or subdivision of the business, that they customarily and regularly direct the work of 2 or more employees, not paperclips, but actual 2 or more employees, that they have the authority to hire or fire employees, make meaningful suggestions and recommendations related to the hiring and firing. And this really comes into effect if you're at the top of your business, you run a smaller business, you're 100% owner, you may not want to give somebody the authority to hire and fire, but at least they have the recommendation of hiring or firing somebody. A meaningful suggestion, right? Like you're going to take into account their advice. That they customarily and regularly exercise discretionary powers, that they are primarily engaged in duties that meet the tests explained in this section, and they earn the minimum monthly salary, of course, of no less than 2 times the state minimum wage. For purposes of exempt salary requirements, full-time employment is defined as 40 hours per week. And then all of these requirements must be met even if the employee is in sole charge of an establishment. So exempt duties must be directly and closely related to managerial work, including interviewing, which is selecting and training employees, setting, adjusting, or recommending pay rates and hours worked, directing the work, keeping production records of subordinates for use in supervision, evaluating employees' efficiency and productivity, handling employees' complaints, disciplining employees, planning work, determining work, distributing work, deciding on types of merchandise, materials, supplies, machinery, or tools, controlling the flow and distribution of merchandise, materials, and supplies. And then lastly, providing for the safety of employees and property of the company. Examples of some non-exempt duties that a supervisor might perform could include performing the same type of work that their subordinates are performing. That could include any production work not part of a supervisory function, although not like the work performed by subordinate employees, making sales, or replenishing stock, or returning stock to shelves, performing routine clerical duties such as bookkeeping or cashiering or invoicing, billing, anything like that, performing any maintenance work. Those things all do not count as exempt duties. Those are all examples of your non-exempt duties. And just to cover some common mistakes. With respect to the executive exemption, the most frequent mistake is the misapplication of the phrase discretion and independent judgment, and the failure to distinguish discretion and independent judgment from the use of independent managerial skills. An employee who merely applies his or her memory in following a prescribed procedure or determining which required procedure out of the company manual to follow is actually not exercising discretion, independent judgment, and therefore is not properly classified as exempt. Another common mistake is with working managers. A working manager refers to an employee with managerial responsibilities and a managerial title who is actually performing work that's primarily engaged in non-exempt duties, cooking, selling on the floor, cashiering, pumping gas, keeping records, taking care of a patient, acting as a desk clerk. Working managers are often misclassified as exempt, and you really want to look closely and analyze the actual job duties of such working managers to determine if they are actually spending more than 50% of their time engaged in exempt activities. So some examples of working managers that are often classified as exempt, but may in fact not be, include service stations, restaurants, rest homes, branch manager or branch retail stores, and then motels. And the industrial wage orders require as a basic condition for the executive exemption that the managers must supervise 2 or more employees, and that may be 1 full-time and 2 half-time employees. So you can calculate it that way as well. But the Labor Commissioner does caution employers that when reviewing classifications, it has been the Labor Commissioner's experience that a managerial employee supervising as few as 2 employees rarely spends as much as 50% or more of his/her day's time primarily engaged in managerial duties. So if an employee supervises only 2 or 3 other people in your office or in your company, the main responsibilities and duties of the supervising employee are often directed towards performing non-exempt functions. So although these functions may require more skill than those functions performed by those subordinates, they may be routine office work or bookkeeping or something else that's non-exempt. So these types of positions really deserve a second look if they have been automatically classified as exempt based on the number of employees that they are serving or that they are supervising. Okay, I see a question in the chat. Have you ever seen any rulings suggesting that an annual salary that meets the exempt threshold and is paid bi-weekly, so 26 installments per year, rather than I think you mean bi-monthly, 24 installments is not adequate because in the months that the employee only receives 2 payments rather than the 3, the employees, no. So I have not actually. That's a great question, as long as it's consistent. So you need to look at what their annual salary is depending on, you know, either way you pay somebody. They don't distinguish whether you pay somebody twice a month or, you know, sometimes 3 times in a pay period or in a month because of your payroll is 26 times a year rather than 24. So thank you for that question. Good morning. It's nice to see a lot of familiar names here. I wish I could see your faces. That would make this so much more fun from my side. But I do that to protect anonymity here. So the administrative exemption applies to a wide variety of employees, right? So however, many employees whose jobs involve administrative work do not meet the administrative exemption test and therefore must be classified as non-exempt. So to determine if an employee is exempt under this exemption, consider the duties that they are performing as well as, of course, their salary. And an administrative employee is exempt from overtime if they have duties and responsibilities that basically are either one or both of these things, that they have duties and responsibilities of office or some type of non-manual work that is directly related to your management policies or general business operations or those of your customers and or the administrative functions of a school system or educational establishment or one of its departments or subdivisions engaging in work directly related to its academic instruction or training. And then additionally, they also, to fall into the administrative exemption, they have to customarily and regularly exercise discretion and independent judgment, regularly and directly assist a proprietor or an employee employed in an executive or administrative capacity under only general supervision that performs work along specialized or technical lines requiring special training, experience, or knowledge, that they are primarily engaged in duties that meet the administrative test and that they meet the required minimum salary. And also, I should mention this, if you guys want copies of my slides, I'm happy to send it to you. Just send me a quick email and I'll make sure you get those. And then I will send out a copy of this recording to you next week as well. I know we had a couple of people arrive late. I'm such a stickler for starting on time and hopefully ending on time. We have so much to get through today. I thought this was going to be like a 20 or 30 minute presentation. And as we were getting into it, I'm like, wow, there's a lot I want to say here. And so I see in the chat a question, is someone who makes 100K automatically considered exempt? The answer is no, absolutely not. You have to look at what their job duties are as well. So if you're paying your employees 100K or more per year, that's great. But that doesn't mean that they're automatically exempt. You need to look at exactly what they're doing as well. And if you could email me, it's hard to keep track in the chat. My email address is just at the very bottom of every slide. Happy to send you a copy of the slides as soon as we're done, and hopefully that will help. So there are 3 types of administrative employees who may qualify for an exemption. And we're going to get into professionals in just a minute. But just going back to the administrative employees who may qualify for an exemption, that is your executive or administrative assistants to whom executive or high-level administrators have delegated part of their discretionary powers. So before you immediately classify your administrative assistant under this exemption, consider that most administrative or executive assistants do not meet this standard because they are not delegated with discretionary powers. And so talk to us beforehand. Like usually your, executive assistant, your administrative assistant are non-exempt. The burden again falls on us as employers to prove otherwise. So make sure you have solid proof if you're going to reclassify somebody. Usually you want to pay those people hourly and keep them as non-exempt. Another thing on the slide is, staff employees who are functional rather than department heads. So this could include employees who act as an advisory specialist to management or to the employer's customers. Typical examples here are tax experts, insurance experts, sales and research experts, wage rate analysts, and depending on the extent to which they exercise discretionary powers. Also included in this category would be persons in charge of a functional department, which could be a one-person department. I know I threw shade on that earlier, but if you have like a credit manager or a purchasing agent or a buyer, a personnel director, a safety director, a labor relations director, someone like that could qualify under this exemption. And then employees who perform special assignments under only general supervision. And often such employees perform their work away from the employer's place of business. So typical titles of these people could be buyers or field representatives. So the California Supreme Court held that work duties qualify as administrative when the employee is primarily engaged in work directly related to management policies or general business operations. Work is directly related if it meets two components. So the work must be qualitatively administrative, like white collar. Employees engaged in servicing a business may be involved in administrative operations if such servicing includes advising management, planning, negotiating, and representing the company. So for instance, an insurance claims adjuster may meet this portion of the test if he, she, or they perform activities such as making recommendations regarding coverage or negotiating settlements. And then quantitatively, the work must be of substantial importance to the manager or operations of the business. So some common mistakes we see here, California courts have confirmed how difficult it is for an employee to meet the administrative exemption. Employers who misclassify employees as exempt may owe the employees unpaid overtime, penalties for missed meal periods, and penalties for missed rest breaks. It also includes interest. It also includes attorney's fees. And because employers generally do not track time for their exempt employees, a court will then rely on the employee's evidence as to how much overtime and how many missed meal and rest periods penalties are owed. And trust me, an employee will say, I've never taken a break. I've never taken a lunch in the 4 years that I worked for you. So even if an employee does not recoup a significant amount of overtime and meal and rest period violations, the employee may have incurred large attorney's fees, which is my whole gripe with California. If you haven't heard me rant about this, if you lose on like a small amount, it could be $1,000, in missed meal periods and missed rest periods, but their attorney fees could be, $200,000. The smaller the recovery does not result in reduced attorney fees. So you're not only having to pay for your attorney on your side of the fence, but also theirs. And that's what's so really disheartening with California law. Courts will focus on whether or not the employee in question is actually engaged in running your business or determining the overall course of its policies. Employees whose primary duties are not related to the company's day-to-day business, who do not participate in the policy making or do not have any impact on the company's operations, are therefore not eligible for this exemption. So the professional exemption, and I know we have a question in the chat about this. So though an employee commonly may be considered a professional, specific legal requirements must still be met to qualify under the professional exemption. The professional exemption extends to 3 categories of potentially exempt employees: those who are licensed, those who are learned, and those who are artistic. An employee who is not a licensed professional could still be exempt if the employee qualifies as a learned or artistic professional, right? So there is a California Wage Order number 4 that lists professional, technical, clerical, mechanical, and similar occupations, and they classify these as non-exempt. Many occupations commonly considered artistic or learned professionals can include, artists, copywriters, editors, librarians, nurses, photographers, social workers, teachers, other than state certified teachers, and some others. So unless an employee is one of these positions that clearly meets one of the exemptions we're going to talk about today, based on the duties of the actual job, the employee must be classified as non-exempt. So a professional employee, that's generally pretty easy to identify. They are exempt from overtime if the employee meets the following requirements: that the employee must be either licensed or certified by the state of California, and primarily engaged in the practice of one of those recognized professions. And these are the recognized professions, right? So you have law, we write the law, so lawyers are of course included, medicine, dentistry, optometry, architecture, engineering, teaching, and accounting, or they are primarily engaged in occupation commonly recognized as a learned or artistic profession. The learned or artistic profession exemption applies when an employee who is primarily engaged in work that either requires advanced knowledge in a science or learning field customarily acquired by a prolonged course of specialized intellectual instruction and study, as opposed to a general academic education or an apprenticeship, and from training in the performance of routine mental, manual, or physical process, or work that is essential part of any of the above, or that they are original and creative in character in a recognized field of artistic endeavor. So that's as opposed to work that can be produced by a person endowed with a general manual or intellectual ability and training, and the result of which depends primarily on the employee's invention, their imagination, their talent, or work that is an essential part of any of the above. And to qualify for the learned or artistic professional exemption, the work must be predominantly intellectual, varied in character, right? As opposed to routine, mental, manual, mechanical, or physical work, and the output produced or the results accomplished cannot be standardized in relation to a given period of time. So to meet the test, the professional employee must meet all of the following requirements: that they customarily and regularly exercise discretion and independent judgment in the performance of the duties that we talked about, that they earn, of course, the minimum salary threshold, which is 2 times state minimum wage for full-time employment. And there is an exception to the salary requirement for certain physicians who are paid. So I'll get into that in a minute. But basically, to meet the test, the professional employee, whether they're licensed or whether they're learned or artistic, must, again, do those 2 things. I have them laid out here. And some individuals practice in, and I see a couple of questions in the chat, I'll get to those. Some individuals practice in one of the 8 enumerated professions but are not licensed. So for example, an accountant may not have a certified public accountant license, or a recent law school graduate may be waiting for the results from the licensing exam. In the past, some treated these unlicensed professionals as ineligible for the profession. However, several courts have ruled that an unlicensed accountant are not categorically ineligible for California's professional exemption. So while the unlicensed accountants and presumably other unlicensed professionals do not actually qualify under the licensed professional category, they may be eligible under either the California's Learned Professional Exemption or Administrative Exemption. And these decisions mean that you as an employer can potentially classify these people as exempt. For example, the Ninth Circuit Court of Appeals has found that unlicensed accountants could still be classified as exempt if they meet the various requirements for a learned professional. And then another court has held that the unlicensed accountants could argue that they meet the administrative exemption. So there is some debate there. It just depends, you know, if an employee is bringing that up as an issue to you, or if you get a demand letter, are you one of the businesses who wants to go, you know, and fight this through the Court of Appeals, obviously through Superior Court of Appeals, and then up to the Supreme Court to get a decision. So a California court actually found that a law clerk who was enrolled in law school but had not yet passed the bar exam was in fact exempt. That still is shocking to me, but the law clerk argued that he was not licensed during that period of time and thus could not meet the professional exemption test. But the court, following an earlier court's ruling on unlicensed accountants, ruled that even though the law clerk didn't have a license, he met the requirements of the learned professional exemption. And then some individuals are exempt because they work in a learned profession. And so there are a few key points here to remember about this test and how it may be applied to learned professionals. And that is the educational requirement for the job that is advanced. This is defined as the person who, to perform his or her day's job, completed a prolonged course of intellectual instruction. You know, that's just kind of going back to a lawyer who just hasn't passed the bar yet. The work must be mainly intellectual, varied in character, and the product or the result of the employee's work cannot be standardized. That they're still spending more than 50% of their time in that type of work, intellectual and varied type of work. And the employee must, again, customarily and regularly exercise that discretion. And so professionals who might be exempt on this basis would include certain consulting or research chemists, physicists, biologists, geologists, if their work and working conditions fit the criteria. In addition, you know, maybe unlicensed law clerks as well. Okay, I see a lot of questions about the artistic professionals. And so in California, relatively few individuals qualify for exemption as members of artistic professionals. Most of those who exert sufficient control over the nature of their own work and over their work hours are self-employed in an artistic profession. The key points to remember about this test and how it may apply to artistic professionals are basically that the employee, again, must be primarily engaged in the performance of work that is original and creative in character in a recognized artistic endeavor. So again, that's opposed to work that can be produced by someone with a general manual, right? Or an intellectual ability and training. And the result of which depends primarily on the employee's invention. It depends on their imagination. It depends on their talent, or work that is an essential part of or necessarily incident to any of the above work. That the term also recognized field of artistic endeavor has been defined to include such fields as music, writing, theater, and the plastic and graphic arts. And then it also includes the work must be predominantly intellectual and varied in character, that the employee must customarily and regularly exercise this discretion and independent judgment, and then of course meets the minimum salary threshold. Now, academic degrees are not required, but a specialized course of study of at least 4 years is generally one element involved in establishing a professional standard in the fine arts. So this element, though, of study by itself is not enough. So it really depends, you know, you need to look deeper, basically. And composers or vocal instrumental soloists may be exempt because of their wide-ranging discretionary powers, including, their control over their working conditions. However, members of an orchestra are not exempt employees. Some writers employed in the motion picture or broadcast industries possess sufficient discretionary powers to be exempt, but most do not, even when working at home, because of the time limits, restrictions on outlines, or other constraints of their creativity. So that's what's really key here with the artistic professionals. How much leeway can you give them? And then how much are you having to wheel it back? I see this a lot with the branding companies that we know. With specific professions, we also represent quite a few physician companies. A licensed physician or surgeon primarily engaged in performing duties for which licensure is required is exempt if they are paid at least the minimum hourly rate set by the state. And we can get into that, but I believe it's like $86 an hour, $86.50 an hour, essentially. Pharmacists are not automatically considered exempt professionals. We have a couple of those as well. Sorry, I'm getting dry, just talking. I should have made this a little bit more interactive. To be exempt, pharmacists must individually meet that the administrative or executive exemption tests. Registered nurses are also something that you have to dive into specifically if you have a company with nurses. You know what, I do see a question sort of about that. So I'll touch on that a little bit more here since we're on the topic of registered nurses. I know someone runs a private mental health group practice. You're talking a lot, thanks. With registered nurses, they're employed to engage in the practice of nursing, do not meet the test for professional exemption unless they individually meet the criteria established for exemption as executive or administrative employees. However, certain advanced practice nurses are to be included in the professional exemption. Certified nurse midwives, certified nurse anesthesists, and certified nurse practitioners may be exempt from overtime if they primarily engage in performing duties for which state certification is required. These employees must meet the other requirements established for the professional employee exemption, including salary tests and then the use of discretion and independent judgment as well. And then beginning just last September, employees providing instruction for a course or laboratory at a private nonprofit college or university can be classified as exempt under this if more criteria are met. I know we represent a lot of tutoring companies, not necessarily college faculty, but something to keep in mind if you happen to be in that type of business. Okay, so an employee is exempt computer professional if they, are intellectual, creative, that they use that discretion and independent judgment, and that they are primarily engaged in duties that basically, I'm not going to read this. This is the computer professional exemption. I don't think we have too many of those people on the call right now, so I'm just going to skip over this because we're really running out of time. These are the requirements here. Well, let me see if I can get to some questions. I'll skip over computer. Oh, you know what? Let me talk about outside sales exemptions because I know we have a lot here with regard to companies who have outside sales people. And really, unlike the complicated requirement for many of the exemptions that I've gone over so far, outside salespeople are exempt from overtime pay, minimum wage, meal and rest periods if they are at least 18 years of age or older, and they customarily and regularly work more than 50% of his or her day's time working time away from your place of business, that they're selling tangible or intangible items, or obtaining orders or contracts for product, services, or use of facilities. So that's it, right? Notably, outside salespeople do not need to meet the minimum salary requirements that is covered under the executive, administrative, and professional exemptions. And then unlike federal law, California does not allow work performed incidental to and in conjunction with the employee's own outside sales or solicitations to be considered exempt. So this distinction is particularly important for route salespeople and then others who may perform functions other than sales during an average day, such as delivery, repair, maintenance, anything like that. And commission inside sales exemption, there's a lot with this as well. Exemptions for some commissioned inside sales employees are contained in the wage orders. The exemption is from overtime pay only, not from the other requirements of the wage order, such as minimum wage, meal breaks, rest breaks, tracking hours. It's only for overtime. And so generally the exemption here applies if the employee earns more than 1.5 times the minimum wage and more than half of the employee's compensation represents commission. So if you're a little bit larger, again, if you have 26 or more employees, the current minimum wage is $14 an hour. To qualify for this inside sales exemption, an individual needs to receive in each paycheck more than $21 per hour worked during the applicable work weeks covered by that paycheck. If you're smaller, you have 25 or less employees, the current minimum wage is $13 an hour. To qualify for this exemption, though, the hourly amount is $19.50. So if you pay commissions twice a month, let's say, make sure your base wage covers this test. The California Supreme Court has held that an employer satisfies the minimum earnings requirement for this exemption only if the employer actually pays the required minimum earnings of 1.5 times the minimum wage for all hours worked during the pay period. And an employer may not allocate wages paid in one pay period to cover a pay period where there may be a shortfall. And so there's more to it there, but let's get into some timekeeping practices. The employees who do not qualify as exempt, you need to keep track of their time. And you have to keep accurate time records of hours worked by your non-exempt employees to comply with both state and federal laws. I still can't tell you how many clients or potential clients I speak to a day where they don't have any timekeeping in place, and it really gives me anxiety. This is new with regard to rounding. I've never been a fan of rounding, actually. We only do it if a client is very insistent on it. But basically, what you need to know here is that there is a new case that talked about rounding that just came out in February of this year, February of 2021. And it's the California Supreme Court case. It's known as the Donahue case. And it basically says that a meal period of less than 30 minutes or taken after 5 hours of work creates a presumption that the meal period is non-compliant. And when a meal period is non-compliant, you're paying your employees a meal period penalty, which is 1 hour of pay. The court held that employers must provide that 1 hour of premium pay for such non-compliant meal periods, or provide evidence that the employee chose to voluntarily waive a compliant meal period. And if you are having your employees waive meal periods, you want to get that in writing each and every time a meal period is waived. You can't just have them sign. I know it'd be so much easier if we could just have them sign something that says, I waive all my meal periods from here on out. You have to stay away from that. You have to do it each and every day, which I know is a pain, but it's what protects you in the end. And then there's just this de minimis time. Employers frequently run into questions regarding counting this de minimis or insignificant periods of time. Lawsuits have been filed over this. I think it was Apple. Don't quote me on that, but I'm pretty sure it was Apple that was just hit with a major lawsuit costing them, millions of dollars because employees before they clocked in, they had to get ready. I've had clients get hit where, you know, they'd have their employee literally spend 10 seconds putting on their hairnet, putting on their, you know, their booties to walk back into the you know, commercial kitchen to do their manufacturing, and that could be considered de minimis time. The California Supreme Court has held that the California's labor code and wage orders have not adopted this federal standard. So basically, don't do it and don't round meal periods, please. Just don't round at all. So overtime, 1.5 times rate of pay. You can read this later. Really running out of time. Double pay for all hours over 12 in a workday, or 8 hours on the 7th consecutive day work. You know, time and a half for the first 8 hours on the 7th consecutive day, and then overtime. Remember, in California, it's over 8 hours in a day. In federal law, it's over 40 in a work week. So you need to be cautious of both of those things. Calculating the rate of regular pay, if only compensation is wages, you know, hourly rate is your regular rate. If the employee receives non-discretionary bonuses or commissions, you have to calculate a different hourly rate, which I think is a pain to have to calculate, and determine whether bonus is production or flat sum. If the bonus is a flat sum, such as $300 for continuing work through the end of the season, you know, a specific formula is required. The flat sum bonus is not designated as an incentive for increased production, but instead, let's say, so the employee remains working for you. To calculate the regular rate of pay when there's a flat sum bonus involved, you have to divide the employer's bonus by the employee's non-overtime hours worked, not by the total hours worked, but just non-overtime. And this provides the per hour value of the bonus, which is multiplied using, you know, time and a half as the multiplier to determine the overtime rate, or 2 times for double time. So I realize these calculations could be complicated, so just make sure you're talking to legal counsel. You know, we work with so many entrepreneurs and people who have founded businesses, which I absolutely love, and they get so creative on trying to calculate this. And they really have, you know, we're to the point in our business where we only represent the best-hearted, best-intentioned employers. And, you know, I've seen some crazy ways to calculate things. So if you have any questions, just run it by me or whoever your employment counsel is. And, you know, meal and rest periods, I think we all know this by now, but it has to be a duty-free meal period of 30 minutes. If they work more than 5 hours a day, rest periods are 10 minutes. Those are paid for every 4 hours worked or major fraction thereof. And then employers should permit and authorize your employees to take these breaks. And meal periods, starting and stopping times really need to be documented. I also recommend documenting break times as well. The Brinker case was a huge case. I was working at a law firm at the time this came out. I have been working in law firms since 2002, straight through pretty much. And Brinker came out, and we were doing employment law, and it was a huge milestone. And the court here basically clarified that an employer's obligation is to provide the meal break, but not ensure that the employee does no work. So according to the court in Brinker, the employer can satisfy its obligation to provide that off-duty meal period if it relieves the employee of all duties, they relinquish control over their activities, they permit a reasonable opportunity to take that 30-minute uninterrupted, and then they do not impede or discourage them from doing so. Off-the-clock work, be careful here. You can read the slide later, but basically, if you're having your assistant send you emails at 11 o'clock at night, they're working off the clock. You need to have an off the clock work policy. If they claim they are working during time, you still have to pay them for the time that they're spent. You can write them up, which we recommend. Some solutions you can keep track of with timekeeping. And timekeeping doesn't have to be something fancy. It really doesn't. It can just be something that is an Excel spreadsheet that you get once a month. Some legal updates. The Farah versus Lowe's Hollywood Hotel. And even though it's the Hollywood Hotel, it's in San Francisco. She was owed commission pay and overtime. The employee here claimed it was justified in omitting, the company, the hotel, claimed it was justified in omitting non-discretionary incentive payments from its calculation of premium pay. And basically, the California Supreme Court said they agreed with the plaintiff here that the term regular rate of compensation and regular rate of pay have the same meaning. It's a big blow to employers who assumed that premium pay would always be paid at the employee's straight time rate, and that's just not the case. Another case, there's two methods for calculating the regular rate of pay that have been developed for employees who work at different rates during a single work week. And this case really discusses that. I know it's 11, so I will go ahead and follow up with the answers to a lot of your questions. Happy to, help in any way I can. 5 most common mistakes: failing to provide those breaks, misclassifying or miscalculating overtime wages, assuming your state law applies. This really happens if you are an out-of-state employer with one California employee. We end up having to represent those companies in court. Classifying all employees as exempt, big problem there. Failing to track employees' time. Really, no matter who your employment attorney is, make sure you're checking in with them a few times per year. Make sure they have an experienced team of attorneys behind them. And then you can always do what's called a liability assessment, just so you can see if there are any gaps. I do have an employment compliant checklist. If you haven't received that from me yet, send me an email. I'm happy to send it to you. And I would love to stay in touch. Text HF Law to 66866. And we will, I don't think I spam and have anyone. If I do, let me know. But really, I just want to keep my clients, my friends up to date with regard to, hey, the Department of Labor came out with this, or there's a new poster, post this, anything like that. Contact information. And I thank you all for coming today. I hope you have a wonderful weekend. I will hopefully talk to you soon. Take care.